The broadcast is now starting. All attendees are in listen-only mode.
Hi everybody, this is Jennifer Schaus, and I've got Bill Bainbridge today with us from Perkins Coie. We're continuing our webinar series, and today's topic is bid protest. Thanks for joining us on a Friday afternoon, and if you're in DC, it's a beautiful day outside, so thanks for tuning in. Our agenda, as usual, we'll go through some brief introductions, some thanks to some of our sponsors. Bill will then jump in on his presentation and give us some good insights on bid protest, and we will then take questions at the end. So as you have questions, type them in on the right-hand side of your screen. You'll see a box over there that says questions, and we will answer them in the order that they're received. As usual, our webinar is being recorded, so if for any reason you need to hop off, or if you weren't able to make this today, we're going to have this available for download probably by Monday morning. So check back on our website for the recording, and we'll now get started. First, I want to thank FedBidSpeed. They're a software provider for government contractors, and their software allows companies to manage FedBids, ops, RFPs, RFQs, sources sought, and various solicitations. It's a great program that can allow you to kind of task other individuals within your company with assisting in the proposal writing and then following the opportunity across the board. Additionally, we want to thank Fierce Government. They're a IT provider, IT newsletter for government contractors. Compared to some of the other companies out there that are putting out content about changes in IT and purchases, government purchases related to IT and cybersecurity, these guys really know what they're doing. So feel free to jump on their website after the webinar and take a look at both of those companies, FedBidSpeed and Fierce Government. Next, I'll give you a quick rundown on Perkins Coie. Bill Bainbridge is an attorney here, and the firm has more than 900 lawyers in various offices around the world. They'll specialize in government contracting as well as commercial law. They work with both startups and Fortune 500. My organization is based in Washington, D.C., a small consulting firm that helps government contractors with GSA schedules and various other certifications, as well as federal sales and marketing. The link to our webinars and the recordings is listed below at the jenniferschaus5.eventbrite.com. We're going to have a series of webinars in May focused on some different topics, so check back with on that site to get the schedule, dates, times, and topics. Okay, now I'm going to turn over the presentation to Bill Bainbridge, and he will take it from here.
Hi, good afternoon. As Jennifer mentioned, my name is Bill Bainbridge. I'm a lawyer at Perkins Coie in the Government Contracts Group, and she asked me to give a brief overview of the bid protest process. So that's what I'm going to do. First question is, and this might seem kind of like a dumb question, but it's really not. What is a protest? Well, a protest is when you file a challenge to the award or the proposed award of a contract, or a challenge to the terms of a solicitation. And the reason this is important, and we'll get into this a little more in some subsequent slides, is you can challenge an agency procurement action either before or after the award. And again, we'll talk about this a little bit more, and you'll understand the relevance, especially of before or pre-award challenges. So in terms of where to protest, there's three different fora that you can bring a bid protest on the procurement itself to. The first one is at the procuring agency. Most procuring agencies have some procedures in place where you can essentially file a letter to the contracting officer, or in some instances a level above the contracting officer, if you think that there's been a problem with the procurement. The next is going to the Government Accountability Office. That's probably what most people think about when you hear the word bid protest. is a protest that's filed at the Government Accountability Office. And then the third is the U.S. Court of Federal Claims. In terms of cost and complexity, obviously a protest to the agency where you're just dealing with the contracting officer is the least expensive route. Kind of the drawback there is that the people who have a vested interest in whatever the decision that has been made, they're the ones that are going to review that decision. So, likelihood of success at an agency is maybe not quite as good. Whereas if you go to the GAO or the Court of Federal Claims, you have an independent body that's doing the review of the procurement action, and so they'll be a little bit more objective in terms of reviewing what the agency did. Government Accountability Office protests are a little bit more expensive than going to an agency in terms of legal costs and so forth, and then going to the Court of Federal Claims would be the most expensive and most complex option. There you're definitely going to have a hearing, and the amount of work that goes into it in terms of the pleadings and so forth is much greater than what would occur at GAO or going to the agency. The fourth thing that I put on there, just sort of as an aside, is you can challenge a company's size status at the SBA. That actually gets filed with the contracting officer first, who in turn will pass the protest off to the local area office of the SBA that is in the geographical area of the company that's being challenged. And we can get more into that during the Q&A, but I just wanted to just sort of put that out there. The other pre-award challenge you can do at SBA is challenging the NAICS. If it's a small business set-aside or if there's a partial set-aside, the contracting officer will assign a NAICS which will determine what the size standard is. It might be 500 employees, it might be $12.5 million in revenue or whatever, and maybe the particular NAICS that's been picked for that procurement isn't a good fit for you because you're too large under that code, but if we go with a different code it may be more favorable and you can qualify as small, oftentimes you can put a case together to challenge the NAICS that's been selected for the procurement, and that's something else that we've done quite a few of those. So go ahead, next slide. So I said we would get into pre- and post-award protests. So when to protest? There's some pretty tight timelines, and they're very strictly enforced, especially at GAO and the Court of Federal Claims. A pre-award protest at the agency or GAO has to be filed before the next round of proposals are due. If there's multiple rounds of proposals, or if there's going to only be one final proposal, then the protest has to go in before then. If you look at the FAR, there's a slight difference. I think at the agency it says that it has to be in before the date for final receipt of proposals, and I think GAO just says it has to be in before final receipt of proposals. So arguably going to an agency you would have to go in the day before, whereas theoretically in GAO you could go minutes before, although you would probably end up being late anyway because of some of the notification procedures that are involved. But in any event, GAO agency has to go in before the award. Post-award, if there's no debriefing involved, so it might be a simplified acquisition or something like that where there's no requirement to do a debriefing, then your protest is due 10 days after notice of award. The date that they announce the award isn't counted, so day one would be the following day, and then you count 10 days from there. If there is a debriefing, first off, if you are not selected, you need to go ahead and request a debriefing from the agency, and that needs to happen quickly. Typically, you have 3 days. I say immediately. I mean, why waste time? Even if you're not going to protest, see what you can find out from the agency. Maybe you'll learn something that you can do differently next time. But certainly, if you are thinking about protesting, you got to have the debriefing because that's where you're going to learn whether or not you even have a basis to protest. Once you've got the debriefing in hand, then you have 5 days from if it's a required debriefing in order to get an automatic stay or suspension. If you don't care about automatic stay or suspension, which would be kind of unusual if you didn't, but if you didn't, then you would just still fall within the 10-day rule from the date of award. Now, I've got a bullet on here for competitive range determinations. This is a kind of pre-award protest. Oftentimes, what agencies will do is they will sort of winnow down the number of proposals before they make a final selection. So maybe they get 10 proposals at the beginning, but they're going to do an evaluation of proposals, and they're going to narrow that down to, say, maybe 3 proposals. So seven of the initial 10 are going to get eliminated from the competition. And oftentimes, companies want to protest that. They want to be readmitted into the competition. That's considered a pre-award protest, but the same time frames apply. So you want to get a debriefing as soon as you can. Sometimes the agency can play some games with how they time the debriefing to sort of trip up your protest abilities. Don't worry about that. Work with your attorney. They'll work through that. But if you are eliminated from a competitive range, you want to get a debriefing right away. And as I said, all these timelines are very strictly enforced. They can get very complicated. You know, some things need to be protested before the award. Some things have to be protested after the award. And again, these are questions that you should be working out with your counsel. So at the Court of Federal Claims, this is the last forum. If you're filing a pre-award protest, the timelines are essentially what they are at GAO. Get it in. It's got to get in before proposals are due. Post-award, there's no set timeline, but what the court does is it follows its own case law that basically says you've got to get it in it, you know, within some reasonable amount of time. So you don't want to just sit on your hands for a year, especially since even if in that case, if you won the protest, okay, you met the timelines at the court, but the contract is already so far down the road, you know, your opportunity to get meaningful relief is pretty limited. So long story short, even though there isn't a strict timeline for post-award protests at the court, you want to move quickly. So what are some things that you should think about in terms of, you know, whether or not you've got a good ground of protest? In terms of pre-award protests, you know, what you're challenging is if you're not challenging elimination from the competition, but you're going to challenge something in the solicitation itself, you know, take a look at whether or not maybe the specifications are overly restrictive of competition. You know, it could be that the agency has made the specifications such that award can really only go to one company. In other words, it might give the appearance that they've sort of, you know, quietly have, you know, earmarked this to go to one company, and so they'll spec the requirements out so that, you know, they know only one company that can meet the requirements. That's something you want to challenge, but you don't want to wait until you've lost the contract, because if you do, you get dismissed at GAO. You'll be untimely. You cannot challenge the terms of this solicitation after proposals have been received. Another thing is whether or not the specifications or the terms and conditions of the solicitation are ambiguous. We're working on a protest right now where the methodology for evaluating costs is ambiguous, and so it's a question of, well, is this something that we need to protest now or wait until after award? And obviously, you know, because it's something that's apparent on the face of the solicitation that it's not clear, you want to protest it ahead of time. Bundling is another thing. If it appears to you that the government is inappropriately bundling requirements, and it should be broken out and set aside as smaller requirements for small businesses. That's something you want to challenge up front. And pretty much any other solicitation problem. I mean, you know your company, you know what is going to be the most competitive and competitively favorable environment for you to submit a proposal. Look at the solicitation, and if there's something in there that you think is going to competitively disadvantage you, discuss it with your attorney and see if that might be a viable ground of protest. In the post-award context, in other words, you've submitted your proposal and you've lost. You've been notified that a competitor has been awarded the contract. You'll get a debriefing, and they're going to tell you, your proposal was evaluated. Technically, it was good or acceptable or whatever kinds of evaluation methods that they've established in the solicitation. But maybe they throw something in there that really wasn't in the solicitation, like they say, you were rated technically acceptable, but we noticed that there might be some risk with you completing transition on time. And you think, whoa, wait a minute. Completing transition on time was not in the solicitation. It wasn't included in Section M as an evaluation criteria. That might be a ground of protest, right? So that's what we call an unstated evaluation criteria. Agencies are required to evaluate proposals based on the criteria that are set forth in the solicitation. It'll be in Section M of most solicitations. And if they deviate from that, that can be a ground of protest. That's similar to evaluation doesn't follow the RFP. Maybe here's another example. Say it's under the terms of the solicitation, price was supposed to be significantly more important than technical qualities. And say your price was $100,000 less than the awardee, but you were only slightly less favorable technically. Well, in that scenario, you could argue, well, we should have gotten the award anyway. Our technical proposal might have been slightly not as good, not quite as good as the awardees, but our price was significantly better. Well, if price was supposed to be significantly more important than technical, then that means that the agency may not have followed the terms of the solicitation. Lack of meaningful discussions. Oftentimes, the government will announce in the solicitation that they're going to hold discussions with offerors. And when they have discussions, they're supposed to be pointing things out to you in your proposal that could lead to your proposal being rated with a deficiency or a significant weakness. Well, if you have discussions with the agency and you think that you've addressed everything that they brought out to you during discussions, and you get your debriefing, you find out that you got a technical deficiency under factor C, and it's new news to you, then it may be that that was something that they were required to disclose to you during the discussions. And if it was, and they didn't, that can be a viable grounds of protest. Conflicts of interest. Oftentimes, especially lately, as the government is farming out some of its procurement functions, where they'll bring in third-party companies to help with solicitations and evaluations of proposals, you may find out that the incumbent might have, because of their role in some other contract, might have potentially had access to your proposal or your proprietary information. There could be a conflict there. Conflicts can get real tricky, so you'll want to work with your lawyer, but it's something that you need to be sensitive to, and it can be a very strong ground of protest. Any other violations of law or regulation, or if you can demonstrate that you were treated unequally. All of these things can be typical grounds of protest that can be successful. But I have to mention, before we go to the next slide, even if the government breaks all the rules, and even if they violate the solicitation, one of the things that you have to be able to demonstrate at some point in the protest process is that you were prejudiced by it. In other words, even if you didn't, you didn't get the award and they made a mistake in the technical evaluation of your proposal, but if your price was so far out of whack that you can't get award anyway, you're probably not going to survive a protest at GAO because you can't demonstrate that because of the mistake you lost out on the award. Right? You have to show that the government's missteps were the cause for you, or but for the government's missteps, you would have won the contract. So that's an important point. So we're getting close to wrapping this up, but you want to think about protests as part of your overall capture strategy. Think about, especially in the pre-award context, I cannot tell you how many times clients have come to me with a complaint about something that occurred. It's after the award, they didn't get the contract, and everything that they're complaining to you about should have been raised in a pre-award protest. So, take a hard look at those solicitations. Work with your counsel to see if there's something in there that you can get changed in the solicitation to make it more favorable for your company. So make that part of your capture process. I mean, it has to be fair, right? We don't want solicitations so that the award is definitely going to go to you because we've slanted everything in the solicitation to you, right? Because that'll get challenged anyway, and you'll probably end up losing the contract. So we want fair competition. But if there's something in there in the solicitation that is, going to reduce your competitiveness and you can get it changed, why wouldn't you do that? So those have to be filed in a timely fashion, and it's got to be before proposals go in. Otherwise, if you submit your once you submit your proposal, then GAO and the court and the agency are going to say, look, you've agreed to, by submitting the proposal, you've agreed to play by our ground rules that we've set up in the solicitation. So even if there is something that seems completely irrational in the solicitation, once proposals are in, it's pretty much too late. Another thing you need to think about is, and this is something that hopefully you're getting good advice from your attorney, but what are the overall likelihoods of success, right? Thinking about that, you sort of have to weigh the costs and benefits of the protest. You have to think about where you probably stand competitively. If you have information that leads you to believe that your proposal was ranked number 4 or 5 or 6 or 29th, a protest may not help you, at least in the post-award context. Yeah, you can file it, but so what? You're probably going to be sending good money after bad at that point because you're not going to. You may, even if you were to win the protest, you're not going to win a contract. So those are things that you need to work out through your attorney. Consider the costs. Agency versus GAO versus the court. Agency protests are inexpensive. It's a way to voice your concern about how procurement is being conducted or was conducted. Chances of success are pretty limited because, like I said, it's all in-house within the agency, and they're going to be loath to criticize themselves. GAO, you get a little bit more scrutiny on the agency action. The court, generally, not in every case, it kind of depends on which judge you get, but as a general rule, my sense is the court tends to show a little bit more curiosity than GAO. If something looks funny, the court may be more willing to dig into the facts to find out whether or not the agency did in fact do something incorrectly. So, but that's also your most expensive option. So, and there can be a combination of these. You can start off at GAO. Here's a good scenario, one that we faced recently. You go to GAO. Your protest is timely. the agency, under the Competition and Contracting Act, is supposed to suspend performance on the awarded contract. But they decide they're not going to do that. Well, GAO is not going to give you a remedy there. They'll still evaluate your protest, and you may still win the protest, but if the agency is moving forward with the contract anyway, then you're sort of left without a remedy. What you may end up doing then is hopping over to the Court of Federal Claims while GAO is adjudicating your bid protest, but going to the Court of Federal Claims to get an injunction against the agency to force them to suspend performance of the contract. Once you obtain that, then you go back to the GAO and continue litigating your protest. So that's not an uncommon situation. It can happen. Some other things to think about. Going it alone without an attorney, it can be done. It's usually not a good idea, and I'll tell you why. What happens is, say you're going to challenge, and it's a worse idea in a post-award context. Pre-award, there may be circumstances when you can do it and you don't need an attorney, but in a post-award context, you're going to challenge an award that was made to another competitor. Part of the review process is the agency is going to produce its record of the procurement, and that's going to include your competitor's proposal. Well, if you don't have an attorney, you are not going to be given access to your competitor's proposal. I can promise you that will not happen. But if you have an attorney, GAO will issue a protective order, and your attorney will be given access to that protected information. They won't be able to share it with you, but they can litigate then on your behalf with, complete knowledge of what was in your competitor's proposal. So, going it alone, especially in a post-award, usually not a good idea. Another thing to think about, defending an award. If you are the awardee and you, shortly after starting the contract, get a letter from the CO that tells you, hey, stop performance, there's been a bid protest, you should consider intervening. If you hire an attorney, you can intervene. Even if you decide, well, we're not going to litigate anything, at least having an attorney that's appearing on your behalf, you can at least stay abreast of what's going on with the protest, what GAO may be thinking, whether or not, if you have the award, you certainly don't want GAO to sustain the protest because you're going to lose your contract then. So you may want to have an attorney as you intervene to litigate on your behalf, and that attorney can work with the agency. I'm doing 2 protests like that right now, where we represent the company that won the award, and we're defending the award. And sometimes you want to do that. Sometimes you need to do that. Another consideration, just because you win the protest or think you're going to win the protest doesn't mean you're going to win the contract. So again, you want to make sure that your attorney is being realistic with you. And oftentimes attorneys don't necessarily think about the distinction of, what your business interests versus your legal interests are. The attorney might be very gung-ho about the protest. You have some great legal arguments, and he or she thinks you're going to win. But at the end of the day, if it's not going to result in you getting a contract, what's the point, right? The only one that's going to make money in that case then is the attorney. So, you want to make sure that your attorney is giving you very, helping you set very realistic expectations for, what do you think that you can accomplish? Make your business objectives. That should be the primary thing for you and your lawyer. What are your business objectives? And if you can meet your business objectives by protesting, if you think you've got some good arguments, and if you think that will lead to you winning the contract, then that certainly builds a business case for filing a protest. Some clients get a little concerned about, well, if I protest, I'm really going to tick off the agency. They're going to be mad at me. They're not going to want to give me contracts in the future. I hear that, but I think, and it can be a real concern, especially for smaller companies that are just getting started. However, I think that's a little bit overstated. I think that, in most cases, in my experience, because the agency, once there's been a protest, contracting officer is out of it at that point, and it's going to get handed over to the agency lawyers to handle. And it just becomes a legal question that gets argued by the lawyers. And people tend not to take it personally. It's just business. And, the other thing to think about, too, is, if you're a company that is never willing to protest, you can be seen as somebody that they can roll over. And, we're never going to give you a contract because we know you're never going to protest it. So those are things you have to think about. You know your relationship with your customer better than probably anybody, but I would say that, yes, bid protesting can raise some issues, but I think sometimes companies overstate a little bit, their concern about, the agency being upset with them for protesting. So, and in terms of, well, what can happen with a protest? Well, yeah, you can win on the merits. You go to GAO and you'll get a decision. Usually takes about 100 days or less. You can win on the merits. Does that mean you'll get a contract? Rarely. Sometimes GAO will direct an award. They will say, Army, terminate this contract to ABC and give the contract to XYZ. It happens. It's rare. Normally, what they will do is they will say, terminate the contract to ABC, reevaluate technical proposals under factors D and F, and then make a new selection, right? So that's why you have to think about, well, okay, so if they reevaluate us under factors D and F, is that enough? Is that going to be enough to make us the #1 selection? So another thing that can often happen, and is happening more frequently, is agency corrective action. So, and this is great because it makes the protest process much, much less expensive for the protester. In other words, you file a protest, the agency lawyers realize from the beginning that you've made some legitimate arguments, and so they will go to GAO and say, look, we've seen the protest. We think that the protester raises some good points. We're going to go ahead on our own and terminate the contract and reevaluate factors D and F and make a new selection. Well, that's great, because then you don't have to go through all the litigation, and basically all you're paying for is to get the protest filed, and it's a great low-cost alternative. I would say, I'm sure my statistics aren't exactly right, but I would say that's happening 30 to 40% of the time now. That's why you want to make sure that when you do file a protest, that you're working with a lawyer who's going to do a legitimately good job on it, and not just throw protest allegations over the transom, see what sticks. That is almost always a bad strategy. Work with your lawyer, make sure that you have very legitimate, meritorious arguments, and oftentimes you can convince the government to do the right thing without having to litigate all the way through. So that's pretty much it, and I can take your questions now. Oh, I'm sorry, I have a conclusion slide. I'm sorry, my bad. So just to wrap up, think about your business objectives when you protest. Protesting is a legitimate part of your overall capture strategy, especially in the pre-award context, where you have an opportunity to shape the terms and conditions of how the government's going to evaluate proposals. Think about those considerations. Think about the legal considerations. Have an honest discussion with your attorney and decide whether or not the legal considerations match and support your business considerations. And if they do, and you can build a business case for it, then maybe filing a bid protest is the right thing to do. Winning a protest and winning a contract are not the same thing. But if you've been eliminated from the competition, or in the pre-award context, or if you've lost the competition in the post-award context, your chances of winning an award without a protest are absolutely zero. So, sometimes you have to go ahead and protest if you want to stay in the mix, if you still want to stay in the competition. Don't forget timeliness. Make sure that your lawyer, if you're not going to somebody who's a very seasoned government contracts lawyer, make sure that they understand the timelines. You miss a deadline and your protest will be dismissed, guaranteed. Keep your attorney involved early. Don't wait until you've lost out on the contract. Get him or her involved. You know, once you get the solicitation, you have 30, 60, 90 days to respond, whatever it is. Go through the solicitation. Have your attorney look at the solicitation. See if there's something in there that doesn't look right. See if there's something in there that ought to be different. And if there is, then you should consider whether or not a pre-award protest is the right thing to do. Now I'm done, and now I can take your questions.
Great. Thanks, Bill, for a great presentation, and thanks, everybody, for dialing in. It looks like we do have a series of questions, which I'll go through and read right now. The first one reads, are there times not to protest?
So from a business standpoint, well, I guess there's two things to think about. From a business standpoint, there may be reason not to protest. You know, a lot of times, like I said, you know your relationship with your customer better than anybody. And, you know, I've seen situations where the government has gone to a company and say, look, you know, you didn't get the award this time, but, you know, we've got this next procurement that's coming down the pike, and we think, you know, you guys would be really good for that. That might be a good reason not to protest. I don't know. You know your relationship. You know if they're trustworthy. You would know if that's something that you ought to rely on. From a legal standpoint, there's lots of times you should not protest. If it's frivolous, if you know that you're ranked number 15, or if you know that you really don't have any grounds of protest, or if you think, you know, if your allegations that are going to support your protest are just basic speculation, and you know you really don't have facts to back up what you're alleging, I certainly wouldn't get involved in a protest like that. Now, hopefully most lawyers wouldn't, but that would definitely be a time not to protest.
Great. I'm going to keep reading through the questions. There is an abundance of questions coming in. We've got about 20 minutes left, so I'll try to get through as many as we can. I'm also going to move on to the next slide, which has Bill's contact information. But still keep your questions coming, and like I said, I'll read them as we get them, and we'll go through as many as we have time for. The next one reads, can you please explain the SBA size protest process?
Okay. So the way it works is, or the way it's supposed to work, and it doesn't always work this way, but the way it's supposed to work is, so you have a procurement that's set aside for small business or some subcategory of small businesses, woman-owned, service-disabled, whatever. What is supposed to happen is approximately 5 days before the award is made, the contracting officer should be sending out a notice of intent to award to all the companies that were in the competition, identifying the company that the government intends to select. That is they're supposed to do that to give you an opportunity to challenge the size of the awardee. And what happens is the protest, if you have a protest challenging the size status of the awardee, that goes to the contracting officer. You basically, like a regular protest to GAO, you set forth your reasons for why you think that this company is not small. Say the size standard is, 100 employees, but you know that, there was the company had a recent news release and they touted the fact that they have 150 employees, or if the size standard is annual revenues of $7 million. And there's been some public release of information where they talk about a banner year and they had 10 million. Those can become a factual basis to challenge the size of a company. So all that goes into the protest. It goes to the contracting officer. The contracting officer then packages this up, and they in turn file it with the local area office of the SBA. And by local, I'm talking about local to the company that is being challenged, not local to you. And that office, that local office, will then forward the protest along with a letter with some informational requests so that the SBA can make a size determination. What happens then is the company will be given, I think it's 3 days, to respond to the SBA's information request. And there's quite a bit of stuff that they have to put together to justify their size. The SBA then, under their rules, has, I believe, 10 days to make a decision. It's not a hard and fast deadline, but it's a goal. They try to get a decision out within 10 days so that they're not holding the procurement up. So if you're the protester and the SBA makes a size determination that says, no, these guys really are in fact small, protest is denied. Well, you can appeal that, and that would go to the main SBA here in DC at the Office of Hearing and Appeals. Similarly, if the local office determines that the company is in fact not small, they can appeal. And if you're the protester, you probably want to get involved in that appeal. So you would want to intervene in the appeal. So in a nutshell, that's kind of how it works. And I hope that answers your question.
Is the bid protest public record, and will the winning company be notified that I'm filing a bid protest?
Yes and yes. So public record. The protest itself will not necessarily become public record. What will become public record is the fact that there is a protest, and eventually, if it goes through all the way to a decision, then the decision itself will become published. Will the company be notified that there's a protest? Absolutely. If they are the awardee, they will get a letter from the contracting officer telling them there has been a protest. They will then, in turn, if you're the protester, you file your protest, say it's a GAO. The following day, you're required to submit a redacted copy of that protest, where you basically take out, any information that you deem to be protected. For example, you might have your pricing in there if you're trying to demonstrate my pricing was better than the other guys. So you might have pricing information in there, or you may have some part of your technical proposal in there because you're trying to demonstrate that your technical solution is better than the other guys. So all that would get redacted out, and then that eventually is going to make its way, the redacted copy will probably make its way to the company that's being protested. So they'll see that. Once there's a protective order, if your concern is them getting your protected information, that should not happen. And if it were to happen, God have mercy on the lawyers that allow something like that to happen, because that would be a violation of the GAO's protected order rules.
Can the losing companies for an award file a collective bid protest?
It's an interesting question. You can each protest in your own name, which happens pretty frequently. And if the protest allegations are similar enough, GAO may consolidate the protests. A lot of times, if you look on the GAO website when they announce a decision, you'll see several companies listed in the name of the case, and that's where they've consolidated, several protests into one. There was one big HUD one, I guess, maybe a year ago. Maybe a dozen companies or something, I think, protested, and they're all listed on there because GAO consolidated them. You may get amongst yourselves and pick a company to be the protester, and maybe people chip in to help out with the legal fees. However, I would caution there, that's fine, you can do it, but just be aware of the fact that if you win the protest, say Company A, who protested in their name, wins the protest, and you may find out that, once the government resolicits proposals or redoes the evaluation, now you're all adverse to each other again. So that could get a little dicey. I've seen it done. I've been involved in a couple of protests where that's been done. I mean, GAO doesn't care who's paying the legal fees. So, I mean, most lawyers don't, as long as, I mean, there's some rules that you have to follow if you have somebody other than the client that's helping out with the legal fees. But short answer to a long explanation, it can be done. It can get dicey if you do. If you're real concerned about costs, work with your lawyer. I mean, there are ways to really do this efficiently and keep a cap on the costs. And especially if you're a small business and you do win or you get corrective action far enough in the process, oftentimes you can get reimbursed for your legal expenses through the Equal Access to Justice, through the Equal Access to Justice Act, EJA. So,
how much does an average bid protest cost?
So, that really varies because it depends on the complexity of the procurement. It will depend on the complexity of the issues that are raised. What my response to that is if you're really concerned about costs, and we've handled protests for some of the largest defense contractors there are, but we handle plenty of protests for smaller companies where they're very sensitive to the legal expenses. What we try to do is we do it in phases to keep the costs in check. In other words, we get the protest filed. That's usually it's a one-time sort of big expense. It may cost $5,000. It might cost $10,000. It just sort of depends on how complex. Again, it goes to how complex the procurement is. It goes to how complex the issues are that you're going to raise. But $5,000, $10,000, maybe on the upper end. And of course, it depends too on the lawyers that are working for you. Depends on what their hourly rates are. But in my experience, we'll say $5,000 to $10,000 will get a very strong protest filed. At that point, unless there's a motion to dismiss, which there might be, and you work with the client on this, and you say, okay, well, look, if there's a motion to dismiss, and we have to respond, this is what we think it's going to cost. And then if we get the agency record, and many times that can be voluminous. I mean, boxes and boxes of documents could be coming into my office, or it might be a couple hundred pages. It just depends. So, but typically what we'll do is we get the protest filed, and then we work with GAO, we work with the agency, and if it looks like the protest just isn't going to get legs, we can pull the plug on it so that you're not incurring legal expenses unnecessarily. On the other hand, if it really looks like you've got a strong protest, then we decide whether or not you want to continue to put money towards litigating it. But there are ways, and if you work with your attorney, to really to keep the legal costs in check. It's something I'm very sensitive to. I think most people are, and they'll work with you.
Great. Word about the 10-minute mark, so I'm going to still try to get through most of these last questions quickly. Can you protest a sole source award or a contract that went out without a solicitation?
Yes.
Okay.
Yes.
Can you protest a GSA schedule award?
You mean award of a task or delivery order under the GSA schedule? Is that? I'll take it to mean that. Yes, you can. If there's been a competition, agencies going to order something off the schedule. There's a competition for it. It can be protested.
Okay. Let me read this again. Can you protest an award that came, from an award from GSA? Okay.
Right.
Okay. Related to the SBA, how can we know the size of the to-be awarded company? Most companies hide the relevant information and the most critical one is usually confidential.
Right. Well, what I would say in a case like that is what you want to do is work with your attorney if you have suspicions about a certain company. And you know, just because, I mean, you know, there's a lot of things that go into size. It's not just a company's headcount or their revenue. If you know, for example, there's a small business set aside to, I don't know, cut the grass at an Army base or something. They're going to do a small business set aside. But you find out that, okay, yes, the company that won the contract is, in fact, a small business, but they're subcontracting huge portions of the work to some large business. Well, that's an SBA size protest right there. So you don't necessarily have to know any confidential information about that company if you can somehow glean some facts about, you know, what their teaming agreements are, what sort of arrangements they've made with their subcontractors. That's one thing. Another thing is you would be surprised what can be found out. I mean, you know, you can do you know, run Dun & Bradstreet reports. You can go through the news clippings and all kinds of things. I mean, for the most part, you know, if you think about it, companies, when they want to go out with a news release or anything like that, tooting their own horn, they don't want to downplay their revenue or downplay their size or capabilities because they're trying to, you know, puff themselves up and make themselves sound better than they are. So, you know, in most cases, what is out there would tend to show them, you know, maybe bigger. So, but you know, law firms have some tools available to reach in and dig out information about companies. And you know, if you have some real strong suspicions about it, you're not able to find something, you can give your lawyer a call. They may be able to find something out for you. Again, timelines are tight, though. You can't sit on your hands. You know, you get 5 days to protest an SBA at the SBA. 5 days from the date you first get knowledge of the company that's been awarded the contract. So that's even tighter than GAO. You don't have a lot of time to do research on one hand. On the other hand, your factual allegations don't have to be quite as tight at the SBA. You've just got to be enough. You got to give them enough to sort of raise some suspicion about whether or not they need to look into it. So you don't necessarily have to go into SBA with hard, cold facts. Just you got to give them something to raise their curiosity.
Okay. We've got a long question here. I'll try to read through it as the screen is kind of small. FAR Part 12 states exact match only set aside for a veteran-owned business. Award made at $188,000. Awardee is a small distributor, and the NAICS used by the manufacturer is not the NAICS in the solicitation, and no waiver of non-manufacturer rule granted by SBA. No sources sought sent before announcement on FedBiz Ops for less than 48 hours via FedBid. Award made today. Is this a viable protest?
It certainly could be. It sounds like there may be issues for both, to go both to the SBA and the GAO. You know, I'd want to get more details to see, you know, how strong those arguments would be. But yeah, I mean, it's definitely, you know, there could be something to work with there.
Great. I think that wraps up our questions. You guys have Bill's contact information on the screen in front of you. Feel free to contact him. We also want to thank, again, Fierce Government and FedBid Speed. And again, a special thanks to Bill Bainbridge and Perkins Coie for participating in our webinar today. Any last words, Bill?
No, thank you very much. My pleasure.
Thanks, everybody.